with the kind permission of all here, ladies and gentlemen, as we conclude the inaugural ceremony, we now begin the first academic session of our workshop. Perhaps no branch of law embodies this philosophy more profoundly than arbitration itself. Over the past 3 decades, India has witnessed a remarkable evolution in arbitration. From legislative reforms to transforming judicial pronouncements, all aimed at making dispute resolution faster, more efficient, and globally competitive. Yet an important question remains. Have we merely amended the law, or have we transformed the culture of dispute resolution? Is it this timely and thought-provoking question that forms the essence of our first session? Arbitration law in India, taking stock and assessing impact. To preside over this important deliberation, we are deeply privileged to have with us Honorable Justice Shri Shyam. Honorable Justice Suman Shyam is a judge at Bombay High Court with extensive experience in constitutional, civil, arbitration and service laws. Enrolled as an advocate in 1996, he practiced before Guwahati High Court and served as standing counsel for High Court and various public sector undertakings. He was elevated as an additional judge of Guwahati High Court in 2015, became permanent in 2017, and now serves at our proud bench at Bombay High Court, contributing significantly to Indian jurisprudence through this thought-provoking and well-reasoned decision. May I respectfully request Honorable Justice Shri Suman Shyam to kindly take the chair and guide today's deliberation. Justice Shyam. It is also my singular privilege to introduce our distinguished speaker for this session, Shri Anil Singh, Senior Advocate and former Additional Solicitor General of India. Shri Anil Singh is one of India's most distinguished legal luminaries and designated Senior Advocate of Bombay High Court. He has served as the longest service Additional Solicitor General of India for the Bombay High Court, Chairman of Bar Council of Maharashtra and Goa, and briefly as Advocate General of Maharashtra. His contribution to the field of arbitration has been exemplary, and he is widely respected for our outstanding advocacy, profound legal acumen, and enduring contribution to the development of Indian jurisprudence. Ladies and gentlemen, it is my honor and privilege to have Mr. Anil Singh, Senior Advocate and former Additional Solicitor General, to address this distinguished gathering along with the Chair. A great audience is finest tribute to a distinguished speaker. Nevertheless, it is our humble privilege to experience our appreciation through a small token of our esteem. May I now request our President, Shri Relekar, Advocates Association of Western India, to kindly come on the dais. Ladies and gentlemen, till we have the committee members back on stage, let me now set the stage for an enriching exchange of ideas. With great respect, may I now request Honorable Justice Suman Shyam to kindly commence the proceedings and lead us through this session, and further invite our distinguished speaker to deliver his address. Let us now take stock of Indian arbitration journey, reflect how far we have come, and thoughtfully consider the road that still lies ahead. Lordship, the chair is yours.
Namaskar and a very good morning to everyone present here. A Saturday morning like this is usually the ideal time to relax at home with the family and get recharged for the week coming ahead. But you have chosen to come all the way to attend this workshop here today by sacrificing your personal time. It can happen, according to me, only in two circumstances. Your passion, commitment towards upskilling yourselves for an effective dispute resolution system, or you must be having formidable opponent in your professional life, so you want to skill up yourselves by attending this workshop. But whatever be the reason, it's a commendable gesture on your part. So thank you very much for attending. I would also like to thank the Western India Advocates Association, Advocates Association of Western India, led by its president, Mr. Prashant Relekar, for organizing this very timely and meaningful workshop at this scale in such a structured and professional manner, and also inviting me as one of the speakers to address the first session. Having said that, as you are aware, the topic of the first session is stock-taking and impact assessment of arbitration law in India. Now, that is a very broad-based, plenary kind of a topic on which one would normally like to speak for hours together, but that will not be necessary, and I am not going to do it for three reasons. Firstly, in the morning session, our Honorable Chief Justice, Acting Justice Ghuge, has given you a very deep insight into various facets of arbitration law. Secondly, I find that there are dedicated sessions to deal with each and every important section of evolution of arbitration law in India and as it stands today. And thirdly, we are running behind schedule. This session was supposed to start at 11 o'clock and we are almost half an hour behind schedule. We'll make up some of the times by adjusting our speeches. But we would also like to have an interactive session where you can ask questions to us, and maybe we can also ask questions to some people sitting in the audience. I can see in the front row some of the doyen stalwarts in arbitration law. So maybe it will be irresistible for us to even ask some questions. So we'll keep about 15 minutes or so for that purpose. But to begin with, a very brief perspective of this topic. As you know, with the growth of cross-border trade, commerce, multinational investments, and the development of the economic sector in India, the need to have a very, very effective, efficient dispute resolution system has been on the cards for last many years. Now, arbitration and mediation are widely believed to be an answer to all the problems we are having in the traditional, conventional judicial system in the country today. This is not only because arbitration and mediation, which go hand in hand, are alternative dispute redressal mechanisms, but also because these are the mechanics which offers smartest way of resolving dispute in modern and complex commercial world with the least consumption of time, energy, and money. Coupled with that, technology is adding much needed tailwind to this process, as a result of which this is, according to me, going to be not only a very, very important option, but probably the most important option for dispute resolution in the coming days. Therefore, as I said, it is a very important workshop for the young and the not so young like me, legal professionals who are in this field. I feel there is a world of opportunity which lies ahead of us, and therefore it is necessary for each one of us to equip ourselves, upskill ourselves on the various traits of this dispute resolution mechanism. I am sure when you walk out of this workshop after the 2-day session, you will do so with much better skills and much sharper strategies while dealing with your assignments in the days ahead. Now, very briefly speaking, arbitration and mediation are not new things for India. Many of you would be aware, these are dispute resolution mechanisms which had their roots in our ancient societies, in our village panchayats and other mechanisms. Mostly, as I come from northeastern India, in northeastern India, the tribal societies are very well defined and very effective dispute resolution mechanism by which they settle very, very complex issues without coming to the court. Now, in India, the Arbitration Act of 1899 was probably the first attempt to codify arbitration law, and that was largely based on the English Arbitration Act of 1889. That was under the British colonial regime. But the Act of 1899 had its limitations because of the times in which it was enacted. This Act was made applicable only to the presidency towns of Calcutta, Bombay, and Madras, as they were called at that point of time. Slowly, we moved on to the Arbitration Act of 1940, which in a way consolidated the law of arbitration in India. But the Arbitration Act of 1940 also failed to deliver in the desired manner. In fact, the Act of 1940 was critiqued severely by the Honorable Supreme Court in the case of Guru Nanak Foundation versus Ratan Singh and Sons. It is a decision which was reported in 1981, 4 SCC 634, wherein the Honorable Supreme Court went even to the extent of saying that it is a lawyer's paradise. The purpose with which this Arbitration Act was enacted, it has failed to completely deliver it due to the rigmaroles of the process, the intervention, judicial intervention at almost every stage, and the process being virtually akin to what you see in the conventional civil court trials. Now, there was a realization in this country for a long time that this Arbitration Act of 1940 is not really what we wanted. It is not going to serve the purpose, and therefore there was a need to change the legal regime completely. It was around that time, or a little, it was around 1985, the ancestral model laws came, and India took a policy decision to align its Arbitration Act, arbitration laws, with the ancestral model law. And that is how the Arbitration and Conciliation Act of 1996 came to be enacted, which replaced the Act of 1940. Now, the Act of 1996 has primarily 4 parts. The part 1 deals with the domestic arbitration and international commercial arbitration seated in India. Part 2 deals with recognition and enforcement of foreign awards. Part 3 with conciliation, and Part 4 with supplementary and miscellaneous provisions. The object of the Act of 1996 was to align the Indian arbitration legal regime with the internationally accepted norms of resolution of commercial disputes. At the center of the Act of 1996 were 3 things. First, the party autonomy. Second, to minimize judicial intervention. And thirdly, to expedite dispute resolution by facilitating effective enforcement of arbitral awards in accordance with the internationally accepted standards. Now, if you look at the Act of 1996, and as I mentioned, party autonomy is the cornerstone of the Act. The Act of 1996 allows the parties to decide on the number of arbitrators, that is Section 10. It allows the parties to decide on the process of appointment of arbitrator. So, as many of you would be aware, Section 11 was interpreted in the Konkan Railways versus Rani construction case, wherein it was held that this exercise by the Chief Justice or his nominee in appointing an arbitrator was merely an administrative exercise. Therefore, it was, after the decision of Rani construction, it was settled that it is an administrative function. However, that position was reversed in the decision of SBP Company and Petal Engineering, wherein the decision of Rani construction was overruled, and it was held that while dealing with an application under Section 11(6) for appointment of arbitrator, the courts will also go into the questions as to whether there is an arbitrable dispute, whether there is a valid arbitration agreement, and so on and so forth. So that had the result of expanding the scope of judicial interference in the process of arbitration right at the stage of appointment of an arbitrator, which was quite contrary to the object of the Act of 1996. That position continued for some time, at least till up till 2015, when this decision was legislatively overruled by carrying out the amendments of 2015 by inserting Section 11(6)(a), which now restricts the inquiry of the court, the Chief Justice or his nominee, only to the question of existence of an arbitration agreement and nothing beyond that. Likewise, the evolution of arbitration law in India, according to me, and many of you would agree, have been a flip-flop development in many ways. In the case of Bhatia International, the Supreme Court had held that implementation of a foreign-seated arbitration would come within the scope of Part 1 of the Constitution of India. This decision had drawn a lot of criticism from the persons and institutions connected with the arbitration field, because it had expanded the jurisdiction of the Indian courts to foreign awards, which was, it was felt that it was expressly excluded under the Act of 1996 so as to ensure finality of such award. Now, this position was further extended in the case of Venture Global Engineering versus Satyam Computer Services Limited, wherein the Supreme Court has further emphasized that a foreign arbitral award could be effectively challenged before the Indian courts under Section 34. However, the situation was restored finally in the case of Balco, Bharat Aluminium Company and Kaisar Aluminium Technological Services Limited, wherein it was held that the principles recognized under the ancestral model law and that of Part 1 would apply only where the seat of arbitration is in India. Similarly, in the case of ONGC versus Sopipe, the interpretation of the expression public policy was expanded so as to bring a challenge to an arbitral award under Section 34 within the ambit of the provision, and further stating that if it is against the substantive law of the land, an arbitration award will be susceptible to challenge, vulnerable to being declared illegal. This position was further extended by the Supreme Court in the case of ONGC versus Western Gecko International Limited, wherein the definition of fundamental policy of India was again expanded. So the result of these decisions were that the Judicial Intervention Against Arbitration Act suddenly went up. But The position was somewhat arrested and rectified in the case of Associate Builder versus Delhi Development Authority, wherein it was clarified that the scope of public policy and patent illegality would be applicable, would only be the grounds where the arbitral award could be set aside. Now, the law on this subject was further consolidated in the decision of Sanyog Engineering and Construction Company Limited versus National Highway Authority of India Limited, which took a view that public policy connotation adopted in the case of Western Gecko would no longer represent the correct legal position. The judicial review under Section 34 would be confined only to the limited statutory grounds, and the courts were prohibited from reappreciating evidence or correcting mere errors in law. Thereafter, the landmark decision in the case of Gayatri Balaswamy, which was referred to the Honorable Chief Justice acting in the morning, is very well known to you. It gives limited power to the court to modify an award, but the courts cannot rewrite an award and on reappreciation of evidence. Now, what I'm trying to emphasize is that there has been a little flip-flop in the development of law, arbitration law in India, even under the 1996 Act, where the Supreme Court has often stretched certain expressions to expand the scope of judicial intervention with regard to the arbitration award, but those positions have also been subsequently rolled back substantively and have clarified, Supreme Court has clarified that there will be limits to which the arbitration award can be interfered with. So today the position is that Indian legal system is in sync with the internationally acclaimed norm that the courts would be loath in interfering with arbitral awards. The party autonomy in case of arbitration should be respected, and the concept of finality of arbitral award, should also be honored and implemented to the extent possible. But the question of party autonomy, as emphasized by the Act of 1996, is not without reasonable fetters. The 1996 Act also lays enough emphasis to the requirement of equal treatment to the parties under Section 18, fairness of the process, which is evident from Section 12, which allows a party the ground to challenge the arbitrator on certain conditions laid down therein, and addition of the fifth schedule now brings in more clarity on what are those conditions. Section termination allows termination of the arbitration and substitution even by agreement of parties, thus affirming and upholding the party autonomy principle, but at the same time giving enough opportunity to the parties to ensure that the fairness standard in arbitration proceeding is never compromised. Section 19 clarifies that provisions of CPC and Evidence Act would not apply, and under Section 20, the parties are free to go for arbitration at any place. 22 permits any language to be used by the parties, and Section 24 says hearings can be held even on the basis of written proceedings. So these are some very fundamental features which I'm highlighting just to project as to the true object of the 1996 Act, which is, as I said, to have party autonomy to its fullest extent while ensuring that the arbitration proceeding itself is not derailed and vitiated due to unfairness, lack of transparency, or violation of principles of natural justice. The Act, the amendments of 2019 are very significant, largely because of insertion of Section 43A to M, which provides setting up of arbitration council, which in a way is a significant step to institutionalize arbitration in India. Likewise, amendment to Section 36, which gives power to the court to grant a stay order if necessary during the pendency of a Section 34 application is a very, very important step towards ensuring that the fairness aspect of arbitration proceeding is not lost sight of while protecting the sanctity of the award which is delivered which is the fruit of the proceeding. Now, I would not like to stretch it further because I think arbitration and mediation brought together offers enormous opportunity, a world of opportunity to the members of the legal professional, the advocates who are in practice today, the judges who may be tomorrow venturing into this field. I would like to tell you one thing. Last week I was in New Delhi attending a conference to commemorate the 60th year of the UNCITRAL, and the topics and discussions that I was able to attend are just amazing. It shows the world of opportunities which are lying ahead of us in the realm of cross-border trade, transactions and dispute resolution opportunities. Mediation is gaining ground in a big manner. There is a session on mediation, as I said. We'll not go into it. But it seems mediation as a process is being effectively used in many countries for resolution of investment disputes and even in IBC matters. I have read articles and gone through papers where I have seen how concepts like smart contract and intelligent decision support system are reshaping the manner in which dispute resolution process is going to shape up in the days ahead. Many of you will be aware, now many countries are recognizing smart contracts as a valid form of contractual negotiation or contractual document where through the use of algorithms, contracts Yes. So, all right, we'll not go very deep into it. We'll have a Q&A session soon after Mr. Singh speaks. Before I conclude, I would like to very briefly say which are the two most important bottlenecks I find in the present day system. According to me, the first is Section 34 and Section 37 of the Arbitration Act. I simply don't see any reason why, after fast-tracking the process of dispute resolution and having the dispute settled through an ad hoc arbitral tribunal of experts, why the matter should come back to the court under 34 and 37. So personally, I feel this is where an institutional appeal mechanism should be envisaged through the Arbitration Council rather than bringing it back to the court. Secondly, I think we have not been able to harness technology in the correct manner and to the fullest extent, which would actually benefit this kind of dispute resolution mechanism. However, I am aware that the 2024 Amendment Bill of Arbitration Act, which seeks to substantially redress this issue, is pending consideration before the House, and I'm sure as and when it is enacted, it will bring in a sea of change and opportunities by inserting technology into the dispute resolution mechanism. I thank you very much for giving me a patient audience, and all the best to you. Thank you.
We are deeply obliged for the insightful session, Lordship. May I now request Shri Anil Singh to kindly address the gathering.
My Lord Justice Suman Shyam, Justice Kulkarni, Shri Gautam Mehta, the President of AWI, senior advocates, members of the bar, ladies and gentlemen. It's a matter of great pride and privilege for me to share the dais with Justice Shyam Suman today and speak on a very important subject, that is the arbitration law in India, taking stock and assessing impact. I'm extremely grateful to the association for giving me this opportunity. This session according to me, is a very important session. And it is true that the parties come to court to seek redressal of grievance and repose their faith in the judiciary. However, it is not a hidden secret that Indian judicial system is burdened with innumerable matters. The sheer number of matters listed every day before each court makes it difficult for all courts to reach before the court and to be heard in an effective manner. I don't want to address on how much pendency is there in the high courts and how many litigations are pending in the country in various courts. Let us take Mumbai, for instance. In most of us who are from Mumbai and Thane are present here, there are a large number of matters filed relating to contractual dispute, which relates including infrastructural project, building construction related cases, matrimonial disputes, maintenance, custody of child, dispute relating to partition, partnership, etc. Now, sometimes it also happens that the matters are filed, ad interim orders are obtained, until you file a reply and get the order vacated. The time which takes, I would say that we make all effort as a lawyer and the judges, but then we have our own difficulties and the matter gets prolonged. The parties are affected, the litigants are affected. I recollect when I was a chairman of the Bar Council of Maharashtra, we had a conference on mediation and arbitration. At that time, Justice Ravindran, the former judge of the Supreme Court, he was heading the mediation committee. And he told us that when he was watching one TV program on one channel, there was an interesting subject and the topic was, are we afraid of courts and lawyers? And when the mic was passed to the participant in the program by the anchor, surprisingly, answer of each and every participant was, yes, we are afraid of courts and lawyers. Though there were limited participants in the program, it conveys the feeling of the ordinary common man. And therefore, according to me, the alternate dispute resolution mechanism, whether you say arbitration, mediation, or conciliation, is very important. And the lawyers and the members of legal fraternity can certainly play an important role in encouraging this mediation, conciliation, and arbitration. Now, coming to the arbitration. Now, arbitration and conciliation, because we have divided our topic into different parts. The first is addressing on the Arbitration Act. The Arbitration and Conciliation Act is primarily based on the United Nations Commission of International Trade, Model of International Commercial Arbitration, 1985. I'm not discussing the relevant provision because there are many sessions, other sessions where the participants, the speakers are there. Justice Suman Shyam has already spoken on those issues. Now there are certain disputes, what type of disputes which can be referred to the arbitration. The disputes where right in rem is involved or disputes which are exclusively reserved by the legislature for adjudication by courts are not capable of arbitration. Right in rem are rights that are enforceable against the world at large. Right in personam operates between two parties. Now there are cases in the Supreme Court where the Supreme Court has laid down or given examples of what type of disputes are arbitrable and what type of disputes are non-arbitrable. The disputes relating to certain disputes which are not arbitrable, like disputes relating to election to public offices, cases involving authority by the court, for example, suit for probate or letter of administration, cases involving serious and specific allegation of fraud, fabrication, forgery, and impersonation, cases requiring protection of court and relating to minors or mentally challenged, cases involving prosecution of other criminal offenses, insolvency proceedings, dissolution or winding up of the company, suits for declaration of title against the government. These are cases which cannot be referred to the arbitration. But there are many other civil disputes or other civil disputes which can be certainly referred to the arbitration, like contract disputes, specific performance, dispute between bankers and customers, dispute between developers and flat purchaser, family dispute, matrimonial dispute, partnership disputes. These are disputes which are arbitrable. Since its incorporation, the Arbitration Act has undergone significant changes, and the amendment more significantly in 2015, 2019, and to 2021. The 2015 Amendment Act introduced a 12-month time limit for arbitral tribunal to make an award, that is Section 29A. Added the 5th and 7th schedule to specify clear guidelines on neutrality, independence, impartiality of the arbitrator. Restricted automatic stay on the arbitral award under Section 26. The 2029 Amendment Act provides for establishing the Statutory Arbitration Council of India to grade arbitral institution, granted the power to appoint arbitrator by designated arbitral institution, added confidentiality requirement for all arbitration proceeding under Section 42A. The 2021 Amendment Act provides amended Section 36 to provide for an unconditional stay of enforcement of arbitration award where prima facie case of fraud or corruption is established in making of a contract or award. Replace the stringent qualification and experience criteria for arbitrators in 8th schedule with the new accreditation norms specified by the regulation. From the above discussion, it can be seen that the arbitral process has changed from time to time owing to changing generation. However, some aspect of arbitration has remained constant. The arbitrations are based on consent of parties who enter into arbitration process, party autonomy, and the notion of minimal judicial interference in the arbitration process. Now, when we come to penetration of institutional arbitration process, that is one of the subject today which remains a major challenge. The institutional arbitration in India is now being encouraged. Institutional arbitration is an arbitration which is conducted by institution established for this purpose. The institution itself lays down the rules for conduct of arbitration proceeding. The arbitration agreement between the parties itself sometimes stipulate the resolution by institutional arbitration. These institutions have their own panel of arbitrators and appoint the arbitrators taking into consideration the nature of dispute, depending upon the subject matter of dispute. The institution itself provides for setup of conduct of arbitration and for publishing, procedure for publishing the award. The institution have their prefix rules, and the procedure normally applies for conducting arbitration is as per the institutional rules. The challenge faced by the institutional arbitration is that sometimes this precise rules or the rules framed by the institutional itself is under challenge particularly the interpretation of the rules. And as we see that there are some differences, the major differences between the ad hoc arbitration and the institutional arbitration is the ad hoc arbitration for appointment of an expert as an arbitrator. The parties to the contract may not be aware who will be the expert arbitrator, but the institutional arbitrator, they have a panel of experts, so you know in advance who will be who can be the expert arbitrator. In ad hoc arbitration, parties can agree to a fast-track procedure or any other procedure which suits them for resolution of dispute. Whereas in institutional arbitration, parties have to abide by the rules framed. If no fast-track procedure is envisaged, then the normal rule will follow. In ad hoc arbitration, the parties can provide for an outer limit for completion of the arbitration proceeding, whereas in institutional arbitration, you have to abide by the rules. Sometimes, if the pleadings are short, it can be flexible in our ad hoc proceedings so that the time limit can be reduced. But normally in the institutional arbitration, you have to go by the rules, by the procedure and the rules set up. So there are some advantages and some disadvantages of our institutional arbitration. But the only matter of concern is that nowadays, our experience is that institutional arbitration is normally a second choice by the lawyers and the litigants. Because the lawyers and the litigants have more trust, faith and confidence in the existing system, that is to go before the retired judges or the lawyers who are mainly doing arbitration work, because they feel that they will get more or better result in the sense that the proceeding will be conducted impartially and it will be heard in an expeditious manner. Now, therefore, as far as logistic support is concerned, there the institutional arbitration may have some advantage because you don't have to make all arrangement for the arbitration proceeding. Normally, when there is an ad hoc arbitrator, the litigants or the parties, they have to arrange for all infrastructure, including the conference room, the stenographer, etc. But these are all already available in the institutional arbitration. So there are some advantages and disadvantages as far as the institutional arbitration is concerned. Now, as far as interference in the award of an institutional arbitration is concerned, we have come across recently a matter in the Bombay High Court where the award of an institutional arbitration was challenged, that is MCIA, in the matter of ERA International versus Aditya Birla. There, the question arose that the arbitrator had some conflict of interest because he had appeared earlier in a matter relating to concerning one party. The representation made by the petitioner therein came to be rejected on the ground that you have to abide by the rules and there is no question of changing the arbitrator. This was challenged before the High Court. The High Court set aside the order of the MCIA and held that if the arbitrator is ineligible, then it will apply even to the institutional arbitration. Another matter of concern as far as institutional arbitration is concerned, that in fact the question of whether the matter below 10 crores or above 10 crores would be filed, that may not be an institutional arbitration, but that is another issue before the arbitrator in the courts, that the question is whether the execution of award, if there is an execution of award, whether it has to be filed in the High Court or Civil Court if the matter is below 10 crores or above 10 crores. This question is still pending in the High Court for adjudication. Now, another question is who will pay the stamp duty on the award at the time of execution. This is also a matter of debate. So therefore, we are also facing, in the sense, the question sometime when we discuss as to there are delay in execution of award. So this is one of the issues which we are facing. Now coming to the state as a litigator. Now, one of the subject in today's session is that whether that the government agencies are walking away from the arbitration. This may not be fully correct according to me, because the government have been participating in the arbitration proceeding. The government have been opting for arbitration. There are various statutory arbitration, there are various provisions where statutory arbitration has been provided, like we have Electricity Act, Forward Contract Regulation Act, Land Acquisition Act, National Highway Act, Multi-State Cooperative Act, Bombay Stock Exchange. So there are various provisions where we have statutory arbitration. Therefore, it may not be correct to say that we are running away from arbitration. And the government have been cooperating in arbitration proceedings also. There may be some cases where the government don't opt for arbitration because where the matter is very, where the government feel that it is not necessary to go for the lengthy procedure of arbitration, but it can be easily disposed of in the court of law, so they may not prefer. But otherwise, normally the government also prefers arbitration. Now, there are other issues like what the bench and bar can do in encouraging the arbitration. According to me, it is ultimately the Bar Association, the Bar Council of India, the members of the bar who can certainly help in encouraging the arbitration. Because it is the clients ultimately, they follow the advice of their advocate. So unless the lawyers and the members of the legal fraternity, they encourage arbitration, it won't be possible. So according to me, the lawyers will play a very important role. I'm not discussing this issue because I'm told Justice Sundaran is here. He has some flight. He has to take a flight, and I don't want to delay the session. Friends, now, therefore, according to me, as a member of the bar, as additional Solicitor General of India, I must only say that the bar has to cooperate for the purpose of encouraging arbitration. We, on behalf of the government, I must tell you one thing, that our Attorney General, the Solicitor General of India, and even the Law Minister have been attending various seminars and functions all over India, and have been discussing this issue. And we have always said that we want to encourage arbitration in the field of even the government litigation, and to see that the pendency gets reduced. And ultimately, what is required to be seen is the trust, faith, and confidence of common man in the system. Because the litigation, which takes longer time, and the delay in the disposal of the matter, that affects the common man, and therefore, according to me, the arbitration would be very helpful, and we are here to cooperate. Thank you very much.
So, do we have about 10 minutes or so for an interactive?
Yes.
Yes.
We have 10 minutes, Lordship. Only thing is that we are now opening the session for question answers in case anybody in the audience would like to ask a question. I request volunteers to be please ready with the mic. Anybody in the audience have any queries, any questions? We request you to please address yourself. The gentleman here.
Enforcement of awards. Thank you. My lords, the most important issue is the enforcement of awards. We get the award, but enforcing it becomes very difficult. And there is no provision as such. So, any light on this aspect? Thank you.
This provision of Section 36 has been now again amended. Of course, as long as 34 remains, 36 will have an impact. But now the discretion is there with the court, either to stay or not stay. If there is only filing an application is not going to operate as a stay. That's the position, right? Does anybody else would you like to throw some light on it?
On execution,
Yeah.
on execution of award, we have some difficulty because normally it is our experience that execution gets delayed. Now it is now for the bar to cooperate, because what happens is that we go on arguing and delaying the execution proceeding. So therefore, because the execution is delayed, the entire purpose and object of the Arbitration Act just was stated. Because we have a time limit of filing, we have time limit for disposal, but we don't have a time limit for 33, 34 and 37, or for execution. Therefore, ultimately it is for the bar to cooperate, because unless we cooperate, we only delay the matters. So execution proceeding gets delayed. So it is ultimately for us, all of us, to cooperate and see that it gets distributed.
In fact, I would like to add one line to what Mr. Singh has said. You see, in execution of an award, we are missing the most important factor. Both sides are not interested in execution of the award. One side wants it to be executed, the other side doesn't want to be executed. So it is not that there is a unidirectional movement happening. In that process, the judge has to balance out the principles, established principles of law, fairness and transparency. So this is bound to take some time, but I do agree these processes there is a need to further simplify these processes. In fact, the 2024 bill, the details of which maybe if somebody can throw light on, primarily seeks to address these issues to some extent while bringing technology into the forefront. So let us wait and see what happens. Yes, any other question?
Thank you, Lordship. We have room for one more question. May I request the gentleman here, please? Sir, may I request you to please introduce yourself first?
Myself, Deepak Kumar Chattopadhyay, practicing in the High Court. In mediation, those who are appointed as a mediator, they have got a training for 40 hours from the High Court level. I am also mediator, 40 hours training. But in arbitration, those who are selected from the arbitration of the Bombay High Court, I have seen most of the ex-justice, judges, police officer, and as well as IAS officer. But there is no training mechanism for the arbitration. And I have seen my experience, most of the arbitration referred from the judges, justice of the High Court, mostly the reputable judges and reputable known person, not to the ordinary, those who are listed in the arbitrator in the list. And there must be a training mechanism for the arbitrator selection. And my question is, Mr. Anil Singh, most of the time I have seen you have to tell government is not interested in electricity cases. I have participate in the Lok Adalat. Most of the time, Lok Adalat is a mechanism to resolve the dispute of the electricity matter between both parties, government and the affected parties.
Do you understand?
Electricity matter, I have participated in the Lok Adalat. That time in electricity matter arbitration process Lok Adalat process resolve hua. There are so many matters in the electricity matter resolved. The government is coming forward also in electricity matter.
Sir, is there a question there?
No, what is your question?
Electricity matter government is proceeding through the Lok Adalat. You are telling in lecture arbitration में आता नहीं है वहाँ mediation में in electricity matter.
All right.
And MSME matter में nowadays the government is not proceeding
All right.
to that.
Can you please, what is the question? I have not been able to understand.
In electricity matter, government.
Understanding the
Sir,
question.
are you
Lok
wanting...
from arbitration.
Sir, may I just frame the
I
question?
am telling you in electricity matter Lok Adalat में the फैसला होता है case dispute in Lok Adalat.
All right. Thank you so much, sir. We have a little time constraint. My apologies
Tough-
to all the
tough
audience for
questions,
more
tough
questions. All right, we'll
Yeah,
take
there
this
must
one
be a
last
training
question here.
mechanism.
Sir, I will request you to please keep it very brief. May I have the mic here? My apologies to everybody else who has queries. The speakers would be available a little later.
Sir, I'm CA, I'm a chartered accountant, Dr. Kamal
Very
Naulakha.
brief, sir. My apologies, but...
But my question is one-liner. Arbitration, we have understood a lot of things to do with arbitration. Mediation, we will also be going through. What about the concept of MEDARB? MEDARB, mediation and arbitration, MEDARB. There's a concept, which is going on, MEDARB, where you mediate and you arbitrate for the same dispute. So is that
Your
concept?
question is to whom?
Sir, to you only, sir, to you, because you have touched on mediation also.
We'll quickly go into it. You see, mediation and arbitration in the modern system is supposed to go hand in hand. This is actually a complementary part of each other. So even under Section 30, I think, the Arbitration Act, there is a scope of settlement. And mediation now has been promoted and used incrementally in settling dispute even when the adjudication process is on. But there is a session dedicated for this. I don't want to go very deep into it. If I leave it half done, then it will not make any sense. But your question is valid. I'm sure when the session is there, you can put it and there can be elaborate answer to that.
Thank you. Thank you, sir.
Is that the last question?
That is the last
Yes.
question, sir.
So before we close, that gentleman has one. Let him ask.
Respected sir, myself is Ganesh Shela. I am also trained mediator. But as you said, sir, some sort of information I want to learn from you. What kind of strategy and mechanism, as an advocate point of view, to apply for the purpose of making aware the litigants for the purpose of going to arbitration? Kindly enlighten us on that point of view.
Your question is to whom?
To that, sir.
Yes,
as
that's
you said about
Sir.
As
That's
far
a-
as,
that's a-
as far as
Yes.
encouraging either mediation, conciliation or arbitration is concerned, now we know what are the advantages of all this mediation, because early disposal, less cost, then the uncertainty which we normally face, that can be avoided. So this is how we have to explain our clients and the litigants. It is ultimately our responsibility. So how you explain your client, how you convince your client, it is for the lawyers to do it. We have been discussing in many seminars on mediation and arbitration that unless we convince the client, it is not possible that they will go, because merely by attending seminar and merely by reading in the newspaper about advantage of mediation and conciliation, the clients won't agree. It is the lawyer to whom the client comes, they have to explain the advantages. So it is for you to explain the advantage. What is the advantage? Within a short time frame, the disposal, you can get a disposal of a matter. There will be lesser cost. There will be no uncertainty. So these are all things which you have to explain your client. So this is
Thank you so much, sir, for this
Thanks a
enlightening
lot.
session. As this enlightening session draws to a close, may I, on behalf of...
Just 1 minute. I have something.
my apologies, Lordship.
This is the last one, and this time it is a question from us. Now, there are many experts sitting here. I personally don't know everyone, but I can see one jurisprudentially a very, very evolved person sitting here in front of us, and from the practical side, insofar as arbitration is concerned, sitting here. That is Justice Girish Kulkarni. I would call him a doyen in evolution of arbitration law, and Mr.
Absolutely, sir.
Gautam Mehta. So, to both of you, I have a small question to ask. You can very briefly give your opinion. I strongly feel that Section 34, of course, this is not for us to do, should be done away by offering a appellate forum through the institutional mechanism in the realm of private tribunals to act as an appellate forum, so that the only judicial interference can be only in the Supreme Court, or at best under 37 in the High Court. This would substantially not only cut down the time consumed in judicial matters, but also affirm the concept of minimal judicial interference in arbitration. So can we have a quick response from both of you, sirs? Can somebody give the mic?
Yes,
And
Lordship.
this will be the last one.
Thank you, Brother Suman.
This is the last laugh you will have.
But I think a lot of deliberation is required on this subject. And I'm not sure whether the Law Commission also has fully applied its mind to this issue, because it would have very serious consequences. I mean, you are completely lifting the whole adjudicatory mechanism under the Arbitration Conciliation Act, and you are conferring jurisdiction on a body which is outside the Act so far. If we are thinking on those lines, how it is to be brought within the purview of the Act, what would be the safeguards, etc., are all matters of consideration, because so far we believe, and the arbitration jurisprudence as we have for large number of years even under the present regime of the 1996 Act. The sanctity of any award being tested in the courts has always been acceptable to litigants. And the problem which I would be discussing during my session is what are these contours and why sometimes, the confidence in the arbitral process in the context of adjudication of 34 proceedings has taken a backseat are all issues. So I think it is worth a thought to be given which indirectly may reduce the pendency. It would be more effective for arbitration. And in that case, the role of the court also would be the appellate, the court under 37 would be restricted. I think time would only decide the issue. Gautam bhai?
Thank you so much, sir.
Thank you.
What Justice Kulkarni said, I second it, but I have a slightly different view. The first thing is that we must recognize one fact, that globally, institutional arbitration is 80%. In India, ad hoc arbitration is 80%. Therein lies the difference. We have to move gradually but surely towards institutional arbitration. We have to have good institutions. We have to have good institution administrators. And that should be the key to working. Coming to this aspect, it's a temporary salve that will work to take away the pendency of 34 from courts and put it before a institution which has an appellate mechanism. But whether it succeeds in long term is difficult because, as your Lordship mentioned, that the most important touchstone of arbitration is consent. Now, if parties do not want to consent to an institutional appellate mechanism, then you're going to go back to 34. And that is a kind of catch-22 situation that the new amendment bill, to which even I commented and sent responses on this particular aspect, how do you deal with this? First, the nation has to make up its mind. Is it going to give primacy to institutional arbitration, or is it going to continue with ad hoc? Once that is done, then you can work this out and make it better. Yes, but you cannot shut out courts completely. So even from an appellate decision, it must go to court for its final test. So the idea is, if you have had 2 rounds, one an award, one an appellate award, both concurrent, I'm sure in 37 when the court deals with it, will view it with some circumspection, why is this party coming to court, That is a practical answer.
Thank you so much. Yes.
Thank you so much for the enlightening session. The session that we are going to now conclude, and the conclusions that I say, before that I will request and I will thank the speakers to enlighten us on this session, though it wasn't theirs. As this enlightening session draws to a close, may I, on behalf of Advocates Association of Western India, express our deepest gratitude to our distinguished chair, Honorable Shri Justice Suman Shyam, and may I request Shri Prashi Chachke to come ahead and felicitate Lordship with garland and bouquet. With a memento and bouquet.
Thank you. This is lovely.
Ms. Tatke is the Vice President, Avi.
Thank you so much. Thank you.
Go ahead.
Wonderful. Thank you. Thank you.
May I now request Shri Rakesh Bhatkar, the Treasurer Avi, to come and felicitate Shri Anil Singh with a memento and a bouquet. May I have a round of applause, please? Some energy in the room.
Thank you. Thank you.
I know it's difficult when they are discussing that we shouldn't go back to courtroom, but I think this is a good topic to think about. Thank you once again for your valuable time, sir.